In this video, we're going to talk about Estate Planning 101. Should I use a trust or not? Hi, I'm estate planning attorney Richard Barid with Smith Barid LLC and one half of the Estate Planning Guys. So, estate planning. I guess we can start by defining estate. A lot of people hear the word estate and they think Bill Gates or Elon Musk or the Rockefellers, but that's not the case. The simple definition of an estate is basically everything that you own. So if you own a home and a dog and a couple of cars and a savings account, that's your estate. And if you are Bill Gates, you've got hundreds of millions, billions of dollars, that's your estate. So everyone needs some form of planning, and Bill Gates' planning may be different than your planning, but estate planning is important for everyone. And one of the questions we get a lot from folks is, at a basic level, should I use a will or should I use a trust? And they're typically talking about a revocable living trust, but let's start with what is a trust? The way we think about it, and sometimes we draw diagrams for our clients, we draw it and think of it as a bucket. The trust is a bucket because it's a container into which you put your assets, and of course a bucket typically has a handle on top. So that handle lets you control your assets. As long as they're in a revocable living trust, you can control your assets. And if something happens to you, so if you become incapacitated or you pass away, you pass that handle off very easily to the next person you choose. So some judge isn't choosing who's going to be your trustee and who's going to be in charge if you're incapacitated or when you pass away, but you get to decide and name the successor trustees, the people who come after you, to control that trust. And if you become incapacitated, then that trustee has a fiduciary duty, the highest civil duty to from one person to another under the law, has a fiduciary duty to use those assets to take care of you. And if you're also taking care of your elderly parents or your kids, the trust can be drawn up so that your successor trustee would use your assets just like you are to take care of not only you or you and your spouse, but your kids and your parents if you're taking care of them as well. You have a lot of flexibility. It's totally up to you what sort of powers you give to your successor trustee. But if we're talking about a revocable trust, and there are many, many kinds of trusts, but at a basic level, a trust is revocable, meaning you can revoke it, terminate it, or change it, amend it at any time, or it's irrevocable, in which case once you set it up and put your assets into it, it's not impossible to change, but it's very difficult to change. And in some cases, you've got to involve a court in order to change it. So when you put together an irrevocable trust, you want to give a lot of thought and pay attention to the advice you get from the professionals helping you into what that trust is going to do, what are the rules for it going to be, who's going to be the successor trustee, who's going to benefit from that trust, and what sort of assets are going to go in the trust. These are all things that a qualified estate planning attorney can help you to think through and to figure out, because while your situation is important to you, it's also important to us, but it's not unique. In most cases, we see people with the same sorts of questions and the same sorts of desires to provide for themselves and for their families and their friends, charities that are important to them. And the tool we use is important only from a technical perspective. What's important is that we understand what you want and what you need your plan to accomplish so we can recommend the right sort of tools. And that's what a good estate planning attorney should do. Not take orders. So someone walks in the door and says, I just need a simple will. Almost everybody says that, and for some people it's true, and some people it's not. But a good estate planning attorney is going to ask you questions, get to know you and know your situation and know what you want to accomplish before we prescribe, so to speak, what sort of trust should be used or what sort of will or what other documents might be used to help define and control your estate. So what can you do with a trust? You put your assets into it. You can pass off the handle, not only when you pass away. Most people come in thinking, what is going to happen with my assets? How do I provide for my family and make it as simple as possible when I pass away? And that's an important thing that an estate plan does. But if you use a will as opposed to a trust, then you're relying typically on a power of attorney if you become incapacitated. Agent you name under the power of attorney should be able to control things like your basic finances, your investments, and other things that you use to make your life go and to run your life from day to day, week to week, month to month, and year to year. So if you rely on a power of attorney, sometimes that's challenging. Sometimes you run into an institution, especially banks, who don't like the form your power of attorney has taken, or it's too old, or you've named co-agents, and some banks won't participate with allow that sort of a power of attorney to be used used with assets at that particular bank. You contrast that with a trust. When you put your assets into a trust, the trustee has control of them. The trust never becomes incapacitated and never passes away, of course, because it's an entity, not a person. And the person you put in control, if you can no longer run your own finances, deal with your own estate, then the person you name as successor trustee, maybe your spouse, maybe a close friend or family member, maybe a professional, can step in, and instead of having to rely on a power of attorney, the trust still owns the assets, and the trustee is clearly legally in control of those assets for your benefit. So you don't have to worry that we're relying just on a power of attorney. So a lot of people think an estate plan, or especially a trust, is only for the wealthy. And what I'd say about that is, if money were no object, we get the question all the time, what should I do? Should I create a will-based plan or a trust-based plan? And the answer to that is, as lawyers often say, it depends. But it's not, a trust is not only for the wealthy, because one of the things we do with a trust is we avoid probate. So even if your assets are not Bill Gates' level of assets, you're going to have some amount of assets that are important to you, and you're going to have people in your life who are important to you. And one of the things we hear very often is, I would like to make things as simple as possible, for things to move as smoothly as possible when I pass away or if I become incapacitated. If you use a will instead of a trust, that's going to have to go through the probate process. Georgia's probate process is not particularly onerous, but it can be onerous depending on who's in charge, right? Who's the judge in the county you're trying to probate something. Some judges are easier to work with than others. Some judges run things a little more smoothly than others. It's not right or wrong, it's up to that judge to apply the law and to help families move things along. But probate under Georgia law, if you dot all the I's and cross all the T's, is designed to take around maybe 6 months or so at a minimum. A trust can be administered fairly immediately. If you become incapacitated or when you pass away, your successor trustee brings us or any other attorney who does what we do proof that you've passed away, usually a death certificate. We create a new certificate of trust, which shows the world that the trust exists, a little bit about what authority the trustee has, and oh, by the way, this is the person who has taken over as trustee. So it's sort of, you can think of it as a power of attorney for the trust. It shows evidence to a bank or financial institution or anyone who needs to know that the trust exists and that your successor trustee is now in control. That can be done in a matter of minutes if it's the right thing to do, if it's the right way to help the client. We don't have this long government intrusion-laden process of probate. Instead, we can move things along and start taking care of the family and distributing assets right away. So the question we get a lot is, should I create a trust or a will? Which one is better and why? We just talked about some of the advantages of a trust, and what I usually tell people if they insist on knowing what I would do, I say if money's not an object, and money's always an object, but if money were literally no object, there's really no reason in almost every scenario why you wouldn't start with a revocable living trust as sort of the hub of the wheel, the center of your estate plan, because it's more powerful than a will and moves things along more quickly in the direction you want them to go, and you get to make all those decisions about what's going to happen with the assets, who's going to get them, how quickly are they going to get them, are they going to have a little helping hand, a trustee for a number of years to help them administer those assets so they don't just burn through all the money at once. So there's a lot we can do, and I do have, we have competitors who sometimes say, well, you have to create a trust because it's going to save you so much money in the long run. And it will save you some money, but it's really, I think, more fair to say it's money now versus money later. So if you pay for a will plan now, that's going to cost you less with most law firms than putting together a trust. But then you're going to guarantee that you need a probate to activate and carry out that will. So if you're a single person, that's one probate. If you're married, two probates. And the cost of probate varies typically from county to county, certainly from state to state. With a trust, it may cost you a little bit more, often will cost a bit more up front. But if everything is done correctly, the assets go into the trust as they should, and your successor trustee is chosen the way you want to choose them, so you have the right person in charge, then we can administer that trust fairly quickly, and there's not trust administration. Getting that certificate of trust out there and answering questions for the trustee is not as long or arduous a process as probate. So trust administration, except in very complex cases, is usually a less expensive venture than probate. So you could spend less money now and push off those probate costs to the future, or you can take care of it all as best we can right now, pay a little more money for the trust, but know that going forward, if something happens to you or when you pass away, your family will have the smoothest possible experience at the lowest possible cost. So thanks for joining me today. If you want to find out how we can help your family, click the button down below and schedule a discovery meeting right now.
I hope you enjoyed that video. If you did, then take a moment right now to subscribe by clicking below and turn on the bell notification so you get notified every time we post up a new video. Right now we're posting 3 videos a week with lots of information about various estate planning topics, so you're going to want to make sure to stay on top of that. Click below to subscribe and click right over here to watch the next most relevant video about estate planning. Go watch it now.